Item number 1 and 4 of the daily list. I am praying for withdrawal of the aforesaid bail application because the same were filed under inadvertently under wrong provision of law. I am praying for withdrawal. Item number 1 and 4. Daily list.
We should have been a criminal appeal.
Yes.
Okay, let him withdraw then.
Yeah.
Okay. What is your name?
R. Khan.
Daily,
Daily list item 1 and 4.
1 and 4. 1, 4.
1 and 4.
Sri R. Khan, learned counsel for the petitioner, has submitted that due to inadvertence, a bail application has been filed, which should have been filed in the form of an appeal.
Appeal.
He accordingly prays for withdrawal, prays for a permission to withdraw the same with a liberty to file in the proper manner prescribed. Para? Also, our Sri R.K.D. Chaudhary, learned, you appear as
DSG.
Deputy SGI. Full stop. Who does not object to the aforesaid prayer. Full stop. Applications. The application is accordingly dismissed on withdrawal with liberty as prayed for.
Lordship, same order in the item 1 and 4. Same.
Yes, same.
Obligation.
Lordship, I beg to mention item 17 on today's list. I'm praying actually for the respondent for I've taken consent of the other side. I'm praying that the matter may be passed over for today, Lordship.
What is the matter about?
Lordship, this is a challenge to a consent to establish of a calcined petroleum coke unit. I am the respondent for, I am the private respondent.
Okay. You have taken the consent?
I've taken consent.
Okay. On the prayer of Sri A. Atreya, learned counsel for the respondent number 4. The matter is adjourned to be listed.
After vacation, Lordship.
Lordship, after a week perhaps, because it has come up today suddenly.
Thank you.
Listed, we give a date then. Listed on 1st of April.
Lordship, first, my senior is not available.
Then on 6th of April?
On the 4th. Yes.
6th of April. Yes.
Lordship, interim may be extended.
Interim order passed earlier stands extended till the next date of listing.
Not respected.
My Lordship, I beg to mention one item, my Lordship, for listing, my Lordship, one I application, my Lordship. There was a delay of 30 days, my Lordship. It's a review petition, my Lordship. Last occasion it was defective. It was unable.
Review before this court.
Before this court has, my Lordship, on 18 December 2025 has, my Lordship, given the judgment, my Lordship. So there was a delay of 30 days. It was filed on February 16. Should
Okay, we'll have it.
Can it be on 26th of this month?
Day after tomorrow?
Today, I mean, can it be 26th, man?
26 is Thursday. Have it on Wednesday. It's a normal consideration day. You have a difficulty on Wednesday?
Difficulty on.
Okay, 26.
Quickly, obvious.
Hi, please, Your
Yes.
Lordship. I beg to mention for listing of 2 separate IAs for suspension of sentence.
First time it will come for first
No, my
time.
lords, the written submission, written objection has also been filed already.
The date was given perhaps?
Yes, on the 19th, but the bench did not sit.
Okay.
19th of March,
Okay, then we'll have it on day after tomorrow.
my lord.
May I please, Your Lordship? A criminal appeal J, it was last heard on 29/11/2024. So I pray to be listed on if allowed by the court on the
You
next.
are an amicus.
No, I'm
You said
No.
criminal appeal J, you have said.
yes.
If
I have
you say
just
J,
said J,
then
yeah, J.
it has to be an amicus. You can say jail appeal. It's a different matter.
Okay, Your Lordship.
It's a regular appeal.
Regular appeal.
Okay, what is?
No. It is a criminal appeal J.
Okay.
J 127 of 24. I have just now been given the wakalatnama from jail actually. So it was last heard on as I have got it is on 29/11/2024. So it was not heard from then. So I pray that it can it be listed for admission on Monday.
Admission, it's not been admitted.
I think it is admitted. Admitted.
Paper book prepared.
Not yet prepared paper.
Okay, have this for orders on Friday. We'll see whether paper book has been prepared. Okay, all right. Yes.
May I please, Lordship?
Yes, please.
Lordship, this criminal revision preferred, my lord, against impugned final order passed by the family court, my lord. And this revision also maintainable before the division bench. And as per notification, my lord, number 30 dated 22/5/2024. Now, accordingly, this matter is listed before this one court. Now, this petitioner ready to pay to his daughter, my lord. But so far the wife is concerned, she has voluntarily had left without any reasonable and justifiable reason. And she is a earning lady. And an earning lady, my lord, cannot claim for any maintenance, my lord. Therefore, this
It is before a DB.
yes, Lord.
Yes, my lord, what had happened, my lord, the pursuant to a notification issued by this honorable court, magistrate of this honorable court, this matter has been referred to the division bench, my lord. As per that, my lord, any judgment passed by the family court, my lord, that has goes to the division bench.
Division also.
Initially,
mandated.
it was before the single bench, my lord.
Civil, criminal, both. Civil, of course, we know.
Civil and criminal both.
Civil, we know, but
Earlier, my lord,
that's
I
the
have,
criminal also.
yes,
Revision,
my lord, the
DB, honorable DB can maintain this.
this notification dated 22/5/2024.
Notification number 30. This appeared on
It has
order.
come up for what?
Yes.
My come out for admission, my lord.
Well, it has already been admitted.
My lord, not yet admitted.
No, it's been admitted. 1/12/2025.
Yes. Admitted.
1/12/25 revision has been admitted.
Yes, Lordship.
We can have it for our disposal date. If you're ready today, we can have it today.
Yes, my lord, because the small issue is there, and one thing, my lord, I must point out here. Due to filing of this petition before this honorable court, my lord, the petitioner have not paid no maintenance to the
No, this is
wife of the
therefore challenge.
wife of the
Actually,
petitioner, even the issuance of the warrant of issue, warrant, my lord, against him.
Then we hear it today.
Yes,
Yes.
yes, my lord.
May hard, my lord, because sole issue, my lord, I have submitted, my lord, before this honorable court that he's
1/12.
Can I have notification? Can I have?
Do you have
can
a
we
notification, that notification? 19?
That 22/5, that the notification you mentioned of the registry. Just
Notification.
to
is
see the
not with
wordings.
me. It was, I think, my lord, on
22.
record. It was placed before this. My lord, kindly produce the order dated 5/2/2026.
5/2/2023. It has also narrated, my lord.
All matters. If
Mr. Islam, your legal aid counsel.
Yes, my lord.
Delay has been,
No delay.
No delay.
It is
No delay.
proper time, my lord. And order dated, my lord, 5/2/2026.
yes,
Para 5 it is narrated.
yes,
That-
what is your case?
Lordship. Lordship, eventually this impugned final order.
Who are you? Give us the facts first.
Lordship. Impugned order, my lord.
No, who are you, Mr. Bhuya?
I
You are the
am
wife and the husband.
I am my lord husband, my lord.
Who filed divorce petition?
Divorce petition file did not divorce petition maintenance
Maintenance.
under section
You,
125.
petitioner is the husband.
Yes, Lordship.
Wife filed maintenance petition.
Maintenance petition.
Under
section 125 CRPC.
125 petition. Thereafter,
Thereafter, the husband also filed WS and with due process.
Contested.
Lordship.
Contested.
Yes, contested. And all both the side adduce evidence.
Yes.
Now, my lord, impugned final order has passed on the basis of evidence on record or not. That is to be taken into account.
Okay.
Now, my lord, the impugn
What do you do?
lordship, I am, my lord, in some extent doing a practice also LLB. After obtaining LLB,
You're an advocate.
advocate in some extent.
Some extent means
Because, my lord,
you do case half, then you go away.
lordship, because he
What is the meaning of some extent?
not because he is also
Only motion,
also a teacher.
no final hearing.
Lordship, he is also a teacher of a secondary school, higher secondary school.
Teacher and advocate.
Because
Your license will go.
No, it is not provincialized. School is not, my post is not provincial. Page 86, my lord. There is a High Court order, my lord. Page 86.
Petitioner, teacher in a non-provincial school.
School post has not been provincialized, tutor, as a tutor. And therefore, my lord, the petitioner also approached before this honorable court.
Also practices.
Yes, in some extent.
Practices law.
Law, my lord.
Anything else you do?
No, I'm saying, my lord, this
Medicine practice, homeopathic.
no, this advocacy, my lord. This is
How much do you earn?
oh, he's earning, my lord, minimum, my lord. His evidence also saying, my lord. And now my contention.
How
here,
much do you earn? What is your monthly income?
income, my lord? Here he stated.
Affidavit was submitted before the court, family court.
And
Access liability.
main issue, my lord, the wife is a earning lady. She has
How
volunteered
much is your income?
income. He stated here, 20,000 per month.
Rajnish versus Neha.
Rajesh Neha, you have complied with?
Yes.
Yes. How much is your income, monthly income?
Here he stated earn around 20,000 per
Huh?
month.
40,000.
Yes, 20, my
20,000.
lord.
Rupees 20,000 per month. Any issues?
Issues, my lord, she had voluntarily had left.
No. Children.
No, one daughter.
One daughter.
And I'm ready to pay to my daughter, my lord.
Daughter stays with whom?
With my wife, my lord.
Mother.
Stays with mother.
And
How old is she?
she, my lord, residing with her parent.
How old is she?
Class 9 student.
Teenager.
Okay. Studying in which school?
Lordship.
Which school?
School in
Where?
Bhella, my lord, in Bhella,
Okay.
Bhella High School. Now at Joruram Pathak Girls High School, Borpeta.
We're not in Bhella, in Joruram.
Joruram Pathak High School. So far her statement, evidence is concerned.
Okay.
TW1.
Where does your wife stay?
With her
Where? Which place?
Borpeta, my lord. Nearby Borpeta, one village, Donia. Donia place. Donia, nearby Borpeta.
And where do you stay?
I am also nearby Borpeta, different village.
What's the name of the village?
Village, my lord, Salekura.
Sale?
Salekura. It is also in and around same locality. Salekura and Zonia is nearby village. Now she, my lord, here, my lord, respondent number 1.
How much maintenance has been granted?
Only 7,000 to my wife and 7,000 to my daughter.
14,000.
14,000. And I'm ready to pay 7,000 to my daughter. And she is earning lady. And she had voluntarily had left without any justifiable reason.
That is your main contention, that she's earning.
And it is admitted fact, my lord, so far her own.
Wife, what is her means of livelihood? You said she's earning. What?
She's earning in school, my lord.
School?
In school, she's getting some salary.
Teacher?
Teacher, my lord.
In a what? Provincial school?
No, my lord. She's a volunteer, my lord, in a tele-education program. Some program has given. In that program, she was engaged contractually for 2,000 per month only. Somehow we continue with his livelihood.
PW1 cross part, it is admitted fact, my lord, that page 36, I joined on 13/8/2022 at Bhella Higher Secondary School as school volunteer. And it is
Is
also
there how many witnesses
two witnesses.
from the wife, petitioner in
He
the
has-
first party?
And her own brother. And own brother already, my lord, this is very important, my lord. Own brother, a cross of PW2, he admitted that on 13/4/2022, my sister again returned to our house, but I did not know the reason. It's admitted fact, but that has not been overlooked in the influence judgment. Her own brother.
Can you presume that by saying that I do not know the reasons, that she had come voluntarily without any cause? He may not know the reasons why she had come. Can you presume
No, it is
that she had on her own volition
and,
pleased to stay with you?
and since after 13/4/2022, my sister first party never returned to house of second party. But why? Reason is not in place.
He doesn't know the reasons.
Yes. That
What has the first party said?
that is the evidence, my lord.
The first party? Her evidence?
First part, my lord, different view.
Wha-
She stated in the
Yes.
complaint,
Yes. No, in her evidence.
complaint saying that she on 23/3/2022 she returned. But evidence says, and so far this before this oral court,
Yes.
her objection here also saying in different view that on 13/4/2022 she
We are
returned.
not on the date. What is the reason assigned in the evidence?
She says that she was misbehaved and tortured, and due to misbehavior and conduct of the first party, she compelled to return back. This is her contention.
Evidence is there, then it is
That
not.
this is a contention, but that has not been corroborated by any evidence, because her own brother has not been corroborated. An own brother saying that he never known on what reason he returned. So if different view arise on the question of evidence, then which one is in favor of the
What is the different view? The view has to be
Because-
inconsistent.
because-
Brother doesn't say.
PW1 saying that he was tortured and misbehaved, therefore she compelled to compelled to return to her matrimonial, to her paternal home.
Okay.
But that has not been supported by her father or mother, and so far evidence is concerned, his own brother, he come to the court and he never reduced that on such reason she returned back. He stated, say, I do not know why, on what reason.
Let us see the evidence
Evidence.
of the brother.
Brother, page 43. 43. Page 43, PW2, cross part of 43. My name is Mustafa Ahmed, son of Abdul Mannan. My age 42 years, so and so religion.
Page, please.
Page 43, my lord.
No, what about 41? 41. 43 is the cross.
Yeah, 41. 41 is
41.
41 Sif. 41 is Sif, my lord. I know both the parties. First party is my elder sister. After her marriage, she never had a peaceful married life. She was.
Oh, what else? What is constantly tortured? What else?
My lord.
Yeah, you have not read the brief probably. You have read the cross part.
She was constantly tortured by the second party for his unlawful demands of land and cash. On many occasions, my sister was driven out by the second party, but I intervened and reconciled. However, the second party continued to torture my sister's first party. On many occasions, my sister reported that the second party threatened to kill her. Eventually, a year back, the second party drove her out along with her minor child. Since then, she is living with us. I do not have sufficient means to maintain my sister. The second party is an advocate and has rich practice. Now, my lord, cross part.
Yes, please.
Page 43.
Hmm.
My sister was married to the second party in the year 2009. As a result of wedlock, a girl child was born to my sister, who is the first party. The girl child is now reading in class 9 and her present age is 14 years. Over the period of 13 years marital life, my sister, first party, used to visit our house several times. We also visited the house of the first party within the said period. That it clearly says that means the conjugal life was peaceful. And after 13 years, a long spell of time, if some dispute arises, in that circumstance also, the wife is not entitled to get any maintenance. The Honorable Supreme Court passed several judgments on this issue. 13 years peaceful life, that is to be taken into account. One village mail was held at the house of Abdul Halim of village Gandhinagar, Borbeta, to resolve between the first party and second party. As per the decision of the village mail, we sent back our sister, first party, to the house of the second party for resuming conjugal life. Because entire people supported that why you return back. You should maintain your conjugal life with husband. That
is one way interpretation, Mr. Bhuya.
Lordship.
Unfortunately, that is not the only interpretation. Sending back
Yes.
to resolve a matter amicably, going back doesn't mean that people have agreed to your.
No, cannot pressurize. Even restitution.
That said, let us try.
Yes.
You go back once.
But when she voluntarily returned back, in that circumstance, he cannot claim maintenance.
Did she
Now-
voluntarily return back?
Yes. Next, 3, my lord, on the next of the said village, male, second party, accompanied by Advocate Abdul Basir and Saijul Ali, visited our house and brought back my sister along with her daughter to his house. So attempt was there to turn back. On 13/4/2020, very important, my lord, my sister, first party, again returned to our house, but I did not know the reason. It is not a fact that in presence of Advocate Abdul Basit and Akbar Ali, my sister left the house of the second party and came to our house with plea of Roza. This is Ramzan. Due to the Roza period, she returned back, but thereafter never turned back. This is the case. And I'm trying. And still I am ready to maintain my conjugal life. And next number, since after 13/4/2022, my sister, first party, never returned to the house of the second party. So this is the case, my lord. Now, my lord, it is clear, my lord, more than 13 years, they had maintained peaceful conjugal life. And now in this aspect, my lord, I would like to refer to one judgment, Honorable Supreme Court.
Yes, please.
Then after peaceful conjugal life, long spell of conjugal life, if wife create dispute, para my lord 20 and 21, material house without any justifiable ground, not entertainable the maintenance.
Without any justice, that's important. Para?
Para 20, my lord, long para, my lord.
Paragraph 20.
20.
20.
Yes. And 21. Here, my lord, may I read? Para 20. I relied upon this.
Is there any stay order here?
No.
Is there any stay order?
No stay.
But you have not paid.
Not paid.
Warrant has been issued.
My lord, I am waiting for the final judgment of this one.
If you are otherwise successful or not successful, you will be
No, I will
heavy
pay.
cost will be imposed
No,
upon you.
I will pay, my lord. Whatever.
Heavy cost will be imposed. You have not complied with the order of the court.
Whether, my lord.
That we are making it clear, very clear.
No, I will ready to pay whatever order passed by the trial court, my lord. I will pay, my lord.
Where is the stay order?
Stay order is in the.
Then why have you not complied with the order of the court?
Have not paid, but why he has not paid?
We are not going to hear you.
Because there is no.
We are not going to hear you.
Because there is no stay order, yet he has not paid.
We are taking action
That
against
has
you.
not been informed me, my lord.
We are taking action against you.
Just I'm come to from my learned friends that has not paid.
Still did not stay.
How do you get an audience from this court?
Outcome of the order, this revision.
Lordship, yes, my
is
lord,
waiting.
because
That's not
the,
the-
my client has not informed, but just like
Where are you? Why don't you advise your client?
he has not whether paid or not because.
Why don't you advise your
have
clients?
you an order? or-
You're a professional, he has come
Warrant
to you.
warrant has been issued by the Connect Court. This is the order of warrant. And that was.
We'll pass appropriate. Let us finish this. We are not going to.
Yes.
Okay, let's finish this. Otherwise, it'll
Yes,
it'll
ma'am.
become
Yes.
complicated. Yes.
Lordship. And apart from this, my lord,
Yes, which paragraph? Paragraph 20. Please.
Paragraph
Please
20.
close.
paragraph
What
20,
is there?
paragraph 20, my lord.
Matrix.
Paragraph 20, my lord.
Living without reason. Living
It appears to
matrimonial
us
without
that
reason.
the parties live happily for many years after her marriage. That is to be taken into account.
There was a report allegedly made by her to the police.
The respondents
It
should
appears
leave
to us
for,
that the
her
it appears-
matrimonial home without any reason.
Okay,
Why the respondents should leave her matrimonial home without any reason.
okay.
And it appears us to that
What is the date of the judgment?
judgment-
Impugned judgment?
impugned judgment, my lord.
30?
305.
35, 2025.
Okay. Yes, anything else?
Lordship, I would like to add here another judgment, my lord. Here also saying that maintenance claim under section 125 refused because there was no justifiable reason for her separation. Paragraph 5, my lord. Because the court has only to consider all circumstances on the basis of evidence brought on record. So we cannot bypass the evidence because evidence of PW2 has not been followed. The court has only to consider all circumstances on the basis of evidence brought on record, and accordingly, paragraph 6, the appeal is accordingly allowed and the judgment of the High Court is set aside. The appeal was filed Ramakaran before the Honorable Supreme Court against the judgment passed by the High Court, and that has been allowed on the ground that evidence on record that has to be followed because evidence of PW2, their own brother, has not corroborated the cross part, and that is to be recorded without reasonable absence. And my lord, I am ready to pay whatever area pending. That should be also recorded, my lord. And my humble submission to this court, I am ready to pay to my daughter whatever passed the judgment by family court. But so far, part of my wife, she's earning lady and educated lady, and on that part, I
On her earning, what evidence did you adduce?
yes. And another thing, my lord, very
No,
important.
that she is earning, what is the evidence?
Evidence, my lord. False statement, so far Rajnish, as a Neha judgment is concerned, evidence filed, and evidence of the DW or PW1, asset and liabilities. Page, my lord, 57.
Yeah.
Everywhere, my lord, no, my lord. Page 61 is very much relevant. She stated, name of employer, housewife. She is also earning, appointed lady. And
No, where is the evidence?
This is my affidavit, my lord.
Affidavit, she has said she's a housewife. If you
And-
want to contradict,
And my lord, page 61,
yes.
paragraph 5, if engaged in the private sector, furnish a certificate provided by the employer stating
Yes.
the designation and gross monthly income of such person may be 100, 1,000.
Hmm.
But here, answer, my lord, no.
Hmm.
So this is also false statement.
No, where only saying false statement, where is the cross-examination?
Yes, my lord, I am coming to process part. TW1. TW1 cross evidence, my lord, page 33.
Page 30?
Page 33. And 31 is the thief, my lord. One is the thief. Here on auth stated that on 23/3/2022, the second party dropped me out from his house along with my minor child. So this is also false statement. So far, my lord, here this objection is concerned. Objection says
Where's the cross-examination?
cross-examination, my lord. Here cross-examination, page 33. Page 33, my lord, relevant portion regarding my lord income. Paragraph 21, my lord. 21, it is a fact that on 13/8/2022, I joined at Bhella Higher Secondary School as school volunteer in tele-education program. I am still continuing the said work. I do not attend the said work regularly, and I do not get any remuneration on off days. It is not a fact that from Destiny HR Solution, I used to get monthly remuneration of rupees 5,000. I only used to get rupees 2,000 per month as monthly remuneration, and additional amount of rupees 800 for miscellaneous school expense. That has not been revealed in the evidence on affidavit. As per Rajnish, as Neha, affidavit file, asset and liabilities. So amount, how much, that is not the issue. Issue is why she filed false affidavit. That is taking into account. Because on the affidavit format, she stated everywhere no income. But here income, some income is there from her own evidence. So this is also a scurrilous attack to the judicial system, my lord. Before the court of law, she adduced false statement.
Let us see your asset and liability.
My asset and liability is whether they are
Page
not
57. Or not, this is of the
liability
wife.
by just one.
Where is yours?
Evidence relation to the with cross part.
Not annexed.
Not.
Why haven't you annexed? It is there. Also, it is there, I think.
Gola 14, right?
I have not annexed.
I think I've seen.
But
Yeah. So page 67, I think.
And Lordship, page 86, my lord. Kindly have a look for a moment.
Page?
Page 86. One writ petition, my lord, 1282, 2022. Here, my lord, three writ petitioner and Gulab Hussain, my lord, present petitioner name appear under serial number 3. He was also one of the writ petitioner. And it was for provincialization of his post as tutor in the Ratnadeep Senior Secondary School. His other post already provincialized, but his post has yet not been provincialized. So he's not earning from this school. Even he also working without remuneration.
Are you an income tax assessee?
No.
Huh?
No.
You're not an income.
No, his post has not been provincialized and
Income tax has got nothing to do with post.
and earning.
Income. Are you an income tax assessee?
Earning is minimum earning. Therefore,
Yeah, you're not answering the court's query.
no, IT return not there.
Then why haven't you not said no? Are you whether assessed to income tax? You have not said no at page 69. You have left everything blank.
69. Lordship.
Yes. Question number 7. Question number 8. Question number 9. Where are your bank statements? You have not filled up anything.
Oh. This is asset and liabilities of Gulab Hussain.
If her affidavit is not correct, your affidavit is also not correct.
But whether he reduced any false statement, monthly income here is stated that 15,000. Page 69.
Thereafter, you have not filled up anything.
If engaged in government service, furnish little salary certificate or current pay slip, school proof of deposit in bank account, if being remitted directly by employer, if engaged in a private sector, furnish a certificate, that is not there. If requisitor benefit, house rent allowance, travel allowance, nothing there. Whether assess if any
So income
subject
tax, you have
copies,
said
income
no.
tax return of the, nothing is there.
You have not said no.
Yeah. Yes, only format printed, my lord. Format printed.
Okay.
But she should here note does not arise or no, nothing is there. That is there, my lord. Only printed.
Did you deduce evidence?
Yes, lordship.
You had deduced evidence?
Yes, lord.
Where is your evidence?
Evidence of DW1.
It's 46 maybe.
Page 46, lordship. Then annexure 5. Oh, this is DW1, deposition of DW1. My name is Gulab Hussain. So something is wrongly typed, my lord. The second party, Gulab Hussain, is my husband. That is right. Our marriage was solemnized as per Mohammedan law and by executing a
Page
register.
46.
Page 46.
46 is Gulab Hussain.
Yes, lordship. He is 56-year-old, my lord, and is still unemployed. And paragraph 4, my lord. First party is qualified of BA passed, masters in Hindi. She has masters in Hindi. She has also passed post-graduation, graduate diploma in computer application. Since before our marriage, the first party was working as assistant teacher at Bonbaria High Madrasa. So it is proved that she is also educated. After 6 months of our marriage, the first party resigned from the post of assistant teacher of the said madrasa without my knowledge and consent. I had to incur a lot of expenditure for successful completion of B.Ed course. I had also incurred huge amount of money for getting appointed as a teacher at Ratnadip Junior College, which is remains venture till date. I am serving as lecturer in the post of education, which remains unprovincialized. In the year 2018, I managed to get appointed the first party as tele-teacher in Jonia High School on contractual basis. She was serving in the said post till date. The first party, without consulting me and without my knowledge, got admitted our daughter at Jonuram Pathak Girls High School at Borpeta, which is situated at a distance of kilometer from our house.
Well, how many kilometers?
So it will more than 10 kilometers, more
You
than
have
10.
written.
More than 10. Yes, not written. When I asked the first party about this, she replied that it did not have any right to ask, as she was the exclusive guardian of our daughter. After March 2022, the first party resigned from the post of tele-teacher at Jonia High School, and she joined in the same post at Bhella High School. Then she also got transferred our daughter from Jururam High School, Borbeta to Bhella High School. This is not all relevant. When my daughter was admitted by the first party at Jururam High School, she went to the house of her parents and started living there at Bhella Bonboria village. On 10/4/2022, a village meal was held in presence of villagers and relatives of both sides. As per decision of the said village meal, I, accompanied by my friend Abdul Basit and Saidul Ali, went to the parental home of the first party to bring her back. Accordingly, first party and our daughter were brought to our house. However, on 13/4/2022, the first party, on the plea of attending Roja Khana, a special party held in the occasion of Ramzan, of her, she went to her parental home along with our minor daughter. Thereafter, she never returned to my house. I visited her parental home on several times to bring the first party and my daughter to resume cohabitation with me, but she refused to resume conjugal life with me. She voluntarily and according to suits we left my house without any just and reasonable cause. I am still ready to accept my first party and my daughter and interested to resume conjugal life with him. The first party never obeyed my advice and suggestion and always ignored me in principal matter of our conjugal life. She also used to rebuke me with filthy words and never gave me the status of her husband. Cross my. I am a lawyer having
Just a minute.
Lordship. Paragraph 11, my lord. However, on 13/4/2000, no, that I already read out, my lord. Paragraph 12, my lord. She voluntarily and according to suit will left my house without any just and reasonable cause. I am still ready to accept the first party and my daughter and interested to resume conjugal life with him. Now that that first party never obeyed my advice already heard, my lord, cross part, my lord. I am a lawyer having enrollment as advocate in Bobata District Bar. I joined Bobata District Bar in the year 2008. In the year 2015, I joined at Ratnadip Junior College as teacher of education, and my post still remains unsanctioned. I know an advocate during his practice period cannot engage in another profession like teacher in his school or college. Admitted. It is not a fact that after 3 months of our marriage, I subjected the first party to torture by demanding land from her parental home. It is not a fact that I intensified torture upon the first party as her widowed mother could not fulfill my illegal demand. It is not a fact that the elder sister of the first party, considering her happiness of our conjugal life, gave some amount of money to me. It is not a fact that I gave trouble to the first party and my daughter by not providing them proper and adequate food, good. Actually, it should be adequate good food. It is not a fact that first party is unable to bear physical and mental torture committed by me, and she was compelled to leave matrimonial home and took shelter at her parental home along with our child. It is not a fact that on 13/3/2022, I dropped the first party after assaulting her from my house. It is not a fact that I did not take care of the first party and my daughter, nor made any provision of their maintenance. It is not a fact that I earn around 50,000 per month as practicing advocate Borpeta, but it is not a fact that I have sufficient landed property at Jonia. So these are to the suggestion. Suggestion, my lord. This witness surprisingly reacts that he has only homestead and land and does not have paddy land. It is not a fact that I earn around 1 lakh from all sources of income per month. It is not a fact that the first party does not get any salary for her as computer teacher at Bhella AC School. This witness has stated that first party earns around 20,000 per month, giving private tuition for her locality. That portion has not been in the suggestion. This witness has stated that the first party earns around 20,000 per month, giving private tuition for her locality. To the court. Have you contacted second marriage? Answer, in the year 2014, I contacted second marriage. As the first party refused to resume conjugal life with me, I was required to contact second marriage as there is none to look after me. I do not have any parents, do not have my parents who were already expired.
But second marriage was done when 2014,
2014.
and she left the matrimonial home when
2022.
22.
So, and sometime she went, returned back and again come. So simultaneously she returned on several occasions. Last on 23. Last on, my lord, 13/4/2022.
No, you had said that there was none to look after you.
Yes.
The first party had left only in the year 2022, so that is not a reason.
But evidence saying that number of times she returned back, and this is the final on 13/4/2022. There is several times.
Your submission will become inconsistent. If you say that you had a happy conjugal life, and yet you married the second time in 2014.
14.
She left you in 2022.
That conduct is
how does it become consistent that you do not have anybody to look after you?
But this conduct also not good, my lord, because she conducted marriage.
Mr. Bhuya, there may not be any restriction in having a second marriage.
Yes.
But that is not a reason that you did not have any because if you say that we had some
He's incompetent.
we had some frictions going on, some relationship was not good. That is not your case. You said we had a very good conjugal life and without any reason she left. And yet in the evidence you said, I need somebody to look after me.
But
Therefore I married the second time.
But so far evidence and the complaint Regarding this second marriage, there is no objection. That is the consented, my lord. In evidence, my lord, nowhere says that without my consent, he got this second marriage. And in complaint, my lord, there is no any such indication, my lord. In the complaint also, nothing is there.
Mr. Bhuya, second marriage is not the issue. She is
Yes.
aggrieved by a second marriage.
Yes, second marriage is not issue.
She is aggrieved by the environment created by you allegedly,
Agree.
for which she had to leave the matrimonial house.
Matrimonial house.
Okay, yes. Anything else?
My lord, everything is there as regard the,
Lordship.
Anything else, Mr. Bhuya?
No, lordship.
my lord, as regard the income is concerned, the evidence of DW2, that is the evidence of the husband, well, kindly see page 53. The cross part, relevant is page 54, my lord. Para 5. The second party, Golabhushan, has been
Who is
practicing.
this DW2?
Malat DW2, his name is Malat Abdul Bashir.
Who is he?
He is one of the friend of the DW1, Malat.
Yes.
The second party, Golabhushan, has been practicing at Borpeta District Advocate Bar for last 14 and 15 years. He is qualified of MA, B.Ed and LLB. He comes to the advocate bar for profession work at least
Page?
page Malat 54.
54,
Yes.
cross-examination.
Yes. The second party, Golabhushan, has been practicing at Borpeta District Advocates Bar for last 14 and 15 years. He is qualified of MA, B.Ed and LLB. He comes to Advocates Bar for professional work at least 4 days per week. My lord. Well, kindly come to para 9.
Hmm.
I earn rupees. It is not a fact that I know that the first party was subjected to physical and mental torture by the second party for which she is compelled to leave the matrimonial. I earn 50,000 per month as advocate. Golabhushan might also earn like me.
That is a suggestion. That is only a guesswork.
That is suggestion. But mal come to the impune order findings of the learned court below.
Hmm.
The relevant portion is at page 83. Para 70. Now, upon appreciation of the evidence, it appears that PW1 and DW1 were living conjugal life for more than 12 years at his house. The evidence of PW1, PW2 prima facie proves that because of physical and mental torture inflicted upon the PW1 on demand of land or cash money in lieu of land by DW1, she left the matrimonial home on several occasions. It is also transpired from the evidence of PW1 that DW1 also physically and mentally harassed her and kept her outside his house during the night time by locking the door from inside when she had gone to fetch water from tube. There is nothing to hold that PW1 had voluntarily left the matrimonial home without any just and reasonable cause. And then, my lord, skip it. Para 17, last part, my lord. The second party has already got married after PW1 had left his house. Therefore, the reason stated above, this court finds that PW1 has left the house of DW1 and physically and mental harassment upon her by DW1 on demand of land or cash money in lieu of the land. PW1, as it appears, earn around rupees 200 to 2,800 per month by working as tele teacher at Bhela High School. She also does not get remuneration for the off days. Therefore, PW1 does not have any sufficient income to maintain herself, not to speak the maintenance her school-going minor daughter. Therefore, the second party, being an advocate by profession and physically able-bodied person, is liable to maintenance to the first party. Now, coming to the quantum of the maintenance, from the evidence of PW1, it appears that DW1 is an advocate by profession and earns around 50,000 per month. DW1's evidence has stated that he joined advocate bar in the year 2008, as he also joined the teacher in the subject of education without salary. He denied the suggestion that he earns 50 per month by practicing an advocate. The cross-examination DW2 proves that DW1 carries on profession of advocacy at least 4 days in a week. DW2 has stated that his income is rupees so and so per month. Collaboration might also. DW1 has been practicing as an advocate more than 15 years. Therefore, his professional income as lawyer can assessed as at least 40,000 per month. Considering the professional income DW1, the market price of essential and also the amount of educational expenditure of the minor daughter reading in class 9, I am of the judicious view that an amount of rupees 7,000 each to PW1 or minor daughter per month at this stage would be adequate to meet the ends of justice. Therefore, the second party is directed to pay monthly maintenance of rupees 7,000 each to first party and their minor daughter from the date of filing of the petitioner. However, it is made clear that while calculating the area's maintenance, the interim maintenance already paid shall be deducted from maintenance. And in fact, as regard the second marriage is concerned, the second marriage was done behind the back of the petition. This is the respondent number 1, my lord. She came to know about the same only in the year 2023. And the torsion inflicting upon the respondent number 1 only because of the fact that he already contacted the second marriage behind the back of the petition. So everything is clear, my lord, and due to the torsion inflicted upon her, she was driven out from the matrimonial house, and now he takes shelter with the widow mother. There is none other. His father already expired, and his brother is also not able to give any financial support to her. So for her livelihood, to maintain her daughter, somehow he engaged with a contextual job, my lord, and got only 2,000 per month. Even in off days, she could not get any salary, my lord. So in that respect, my lord, I have to place 2-3 judgments, my lord.
I think he should not have mentioned as housewife in the affidavit. After all, it's an affidavit.
Yes, well, that was subsequently.
He admitted in course that she has not
Yes,
stayed.
yes,
That's
yes.
true, but
That is admitted.
still. Yes. Yes.
That first judgment reported in 2008 to SCC 316, para 6, my lord. The object of maintenance proceeding is not to punish a person for his past neglect, but to prevent the vagrancy by compelling those who can provide the support to those who are unable to support themselves. And we have a moral claim to support. The phrase unable to maintain herself in the instant case would mean that the means available to the deserted wife.
Paragraph?
Para 6. Paragraph 6. Got it. The object of maintenance proceeding is not to punish a person for his past neglect, but to prevent vagrancy by compelling those who can provide support to those who are unable to support themselves and who have a moral claim to support. The phrase unable to maintain herself in the instant case would mean that means available to the deserted wife while she was living with her husband and would not take within itself the efforts made by the wife after desertion to survive somehow. Section 125 CRPC is a measure of social justice and is especially enacted to protect women and children as noted by this court in Captain so-and-so, falls within the constitutional sweep of Article 15(3), reinforced by Article 39 of the Constitution of India. It is meant to achieve a social purpose. The object is to prevent vagrancy and destitution. It provides a speedy remedy for the supply of food, clothing, and shelters to the deserted wife. It gives effect to fundamental rights and national duties of a man, maintain his wife, children, and parents when they are unable to maintain themselves. The opposite position is highlighted in so and so, so and so. Under the law, the burden is placed in the first place upon the wife to show that the means of her husband are sufficient. In the instant case, there is no dispute that the appellant has the requisite means, but there is an inseparable condition which has also to be satisfied, that the wife was unable to maintain herself. These two conditions are in addition to the requirement that the husband must have neglected or refused to maintain his wife. It is to be established that the wife was unable to maintain herself. The appellant has placed the material to show that the respondent wife was earning some income. That is not sufficient to rule out the application of section 125 CRPC. It has to be established that with the amount she earned, the respondent wife was able to maintain herself. So here in this case also, Manoj, she somehow get the in some months 2000 and some months less 2000. Because in off days, she will not get the remuneration. And her daughter now reading in class 9 months, his tuitions and other facilities, because from the parental house, nothing has been given to her because they are not financially sound at all. And next, the judgment of our High Court, passed by the learned single judge in a case of Mohim Ali versus State of Assam and others. In this judgment, para 14, it has clear.
14 has taken help of Chaturbhuj.
Yes.
Chaturbhuj you have already cited.
Yes.
Chaturbhuj
yes,
already cited.
Yes.
You cite judgments of a court which is at least concurrent of a coordinate bench, not of a single bench.
Yes, Chaturpur judgment is there.
Chaturbhuj is there.
May I submit one thing, my lord?
No, let him finish.
Oh, finish.
One more is there.
In this judgment, para 14,
Which one? Last one.
this Mohim Ali.
Mohim Ali, don't cite single bench. Doesn't look good, Mr. Islam.
Yes.
You can take 8 of the judgments of Supreme Court which have been referred in that judgment. We have already seen Chaturbhuj.
Yes. Then another last one, para 10.
Of
Para 10 of the judgment of Mustaq Ahmed.
a single bench.
Yes. Chaturpur judgment is there.
Yes.
My humble submission, the respondent number 1 is not sufficient to maintain herself and her daughter, and at this stage, though the learned court below has already directed to pay the maintenance, and after filing this petition, the petitioner did not pay a single penny to her, and for that, the warrant has already been issued by the learned court below, and after issuance of the warrant, that was issued long back on 2/2/2026. Till date, he did not have paid any single penny.
Even warrant is.
Yes, even issuance of the warrant. This is his conduct, and the torture inflicted upon the respondent number 1 behind the motto is that he already contacted the second case behind the back of the petition. Respondent number 1. This is my humble submission. So the maintenance is allowed by the learned court below is sufficient. There is no ambiguity in the judgment.
So, Bhuya, any rejoinder?
Lordship, I would like to one thing to notice on this one court. But in the complaint, as well evidence, there is no single whisper whether the assault, criminal force, demand has been proved by your evidence, because there is no any complaint before the concern of any police station
Let us see the complaint.
regarding 498.
Let us see the complaint.
Complaint, my lord, Assamese vernacular, my lord.
No, there is an English also.
Page 20.
18 you have given 80.
Page 20.
Yes.
If such type of allegation, but that has to be 498 is there, that is not there.
Is it necessary that 125 has to be preceded
No,
by a
that is not
498A?
related, but question is if assault demand is there.
No, is it a prerequisite that to maintain a
Not-
petition
not-
of
not- not
125,
necessary.
you have
125
to have a 498A?
125 non-necessary. I would like to relate because whether the contention is true or false, that is the real.
In second paragraph, that for a few months of my marriage, my conjugal life was happy. Thereafter, I was subjected to torture in the name of illegal demand of my land and money. That has been given at page 18.
Yes. Illegal demand.
Not
and-
satisfying torture, he did not give proper food and threatened to kill me. This may be false, this may be true. These are different matters. But you cannot say that pleadings are not there.
No, page 22, my lord, SMS ভার্নাকুলার এইখিনিতে ক্ষান্ত না থাকি দ্বিতীয় পক্ষৰ মাটিৰ লোভত অত্যাচাৰ দিনক দিনে বাঢ়ি যায় খোৱা লোৱাত মোক ছোৱালীজনীক কষ্ট দিব ধৰে আৰু মোক মাৰি পেলাব বুলি ধমকি দিয়ে। So this allegation, if there attempt to murder or and threaten, but there is no police case, so it cannot be. So entire fact this reveals tantamount false. And she is earning lady in some extent. How much, that is not the issue, but some extent she is earning lady. That is not disclosed. That is the concealment of fact. So far evidence is concerned, or evidence is concerned. So concealment of fact is there. So that is my submission, my lord, and she had voluntarily had left. And so far village mail is concerned, there is sufficient village evidence is there. And it is privacy established, she had voluntarily had left and she never returned back. So if someone voluntarily had, that is, in short, deserted wife is not entitled to get any maintenance. This is my submission. I am ready to pay to my wife, daughter is concerned. Daughter portion I am ready to pay. But so far, the deserted wife is not entitled to get any maintenance. And after conjugal life more than 13 years, at this stage, why she claimed this type of allegation? That's all, my lord.
Family court seconds, huh? Actually 19-4 হব লাগিছিল 19-4 হব লাগিছিল 19-4 হব 19 টাকে 19 chapter nomenclature to so to me this is an application under 438 444 it's sense of the BMSS. This is not equivalent to revision. This equivalent is revision only revisions.
Own motion can or otherwise. Revision is correct.
No, notification not correct. Notification not correct. 6 is only in appeal.
Yes.
Only in appeal.
এখানে
Can we have a look at the notification, madam? The 22nd? Yes. No, since we have heard, there is no problem. We'll decide, we are going to write the judgment. Because if you come to chapter 5 of the Family Courts Act, chapter 5 is not restricted to the aspect of appeals. Chapter 5 is for appeals and revisions. Do you have the Family Courts Act? Kindly have Mr. Islam might be having. Chapter 5. Do you get chapter 5? Section 19. Mr. Islam, please help her. Chapter 5. Section 19.
Sub clause. Section 9.
No, not subclause. We'll read the entire thing. Let us understand. Let us deliberate and understand. 19 says appeals, but the chapter 5 is on appeals and revisions. Okay. So 19.1 is the actual the appeal. Save as provided in subsection 2 and notwithstanding anything in consequence of CPC or the CRPC or any other law. So this is got an overriding effect. An appeal shall lie from every judgment or order not being an interlocutory order of a family court to the High Court on facts and on law. Appeal shall lie from every judgment or order not being an interlocutory order. Okay. Now, no appeal shall lie from a decree or order passed by the family court with the consent of the party or from an order passed under chapter 9 of the CRPC. Okay. So, chapter 9, what is covered? Appeal will not lie. Then, 3. Every appeal under this section shall be preferred within this is the limitation period. Then 4 is very important. 4 is the revision power. The High Court may, on its own motion or otherwise, it may be so moto, it can be on a basis on application or otherwise, call for and examine the records of any proceeding in which the family court situate within its jurisdiction passed an order under chapter 9 of the CRPC. This is the chapter 9, which was barred by an appeal. This is provided by way for revision for the purpose of satisfying itself as to the correctness, legality or propriety of an order not being an interlocutory order and so as to the regularity of such proceedings. That 5, except for no appeal or revision shall lie to any court from any judgment, order or decree of a family court. Then 6 is important. An appeal preferred under subsection 1 shall be heard by a bench consisting of 2 or more judges. So it is only in an appeal which is to be heard by a DB. So in that context, we wanted to look at that notification of 22nd. This is not an appeal. It's not that all orders passed by the family court has to be heard by a division bench. It's only when appeal is filed. This is not an appeal.
But already you have got the order to the amount of the following.
No. You have not understood. What is an appeal, madam? You should understand.
Order is not satisfied, Lordship, then it is.
No. It's not that. You can come to the High Court by of an appeal, by of a revision. In which case appeal will lie, in which case revision will lie.
Yes.
The statute has made it very clear.
It is statutory.
Yes, statutory. That notification, Lordship, we have got it, Lordship, that whether it will lie on.
Madam, you have to understand, not like this.
Lordship.
You read, you understand, then you make submissions.
Lordship, an appeal preferred under this section shall be heard by a bench consisting of 2 or more judges.
So in which cases appeal will be there? In which case revision will be there?
When the judgment is from there and that's not satisfied, then revision will lie, Lordship. When they were.
Suppose the degree of divorce, will a revision lie?
No, Lordship.
Why? That is not satisfied.
That is not satisfied.
Then your
Still not.
analogy will not work here. You will work here.
Lordship.
You have to understand where appeal lies, where revision lies.
Lordship.
The statutes makes it very clear. Read the statute, understand.
Lordship.
Suppose there is an order under the Hindu adoption and maintenance act.
Lordship.
Whatever. So in that case, it will remain lie. But this is a 125.
125%.
On that same, my lord, I have made this submission.
Yeah.
After recording my submission, that was referred to the registry. my lord. And subsequently, the registry has registered. to the
Actually, the registry
division.
notification is.
On that day, I have made this.
Then in case of appeal, is mandatory to be heard by a division bench.
Lord.
But in case of revision, High Court on the administrative side, in my humble opinion, can still decide to be decided by a division bench, as has been done here.
Lord.
But if it is heard by a single bench,
Bench,
it is not in violation of the Family
No.
Courts Act.
but only due to the notification. it is-
Yes, notification.
Now, one more respect, madam, since we're, you see where subsection 2 of 19,
No appeal,
provided that nothing in this subsection shall apply to any appeal pending before a high court or any other orders passed under chapter 9 of this so and so. So for a pending appeal, it is not applied. Then the first, the subsection 2, no appeal shall lie from a decree or order passed by a family court with the consent of the parties. That is one part. Or from an order passed under chapter 9 of the CRPC. So what is chapter 9?
Maintenance.
This is 125.
125 proceedings.
Chapter 9 is order of maintenance for wives, children, and parents.
Lordship.
So if it comes under chapter 9,
Nine.
appeal is barred.
Five.
So you fall back on 19.4. 19.4 is the revision power.
Lordship.
And so far as revision is concerned, there is no mandate of the statute that it should be heard by a DB.
Division.
It is only for an appeal
Mm.
which is required to be heard by a DB. So that is the distinction.
That order. Lord.
Okay. Okay.
Application is there.
Let's see. Funny, anybody? No, it's okay. We have heard. We are going to dictate. The instant application, instant revision petition has been filed against a final order dated 30/5/2025 passed by the learned family court, Warpata, in a proceeding under section 125 CRPC, registered as FC within bracket criminal case number 509 of 2022. Full stop. By the aforesaid judgment, maintenance at the rate of rupees 7,000 to the second party wife and an equivalent amount for the daughter have been granted. Full stop. Para. The facts which reveal from the case records is that the second party wife had instituted the aforesaid proceeding by filing a complaint before the learned family court Borpeta. Full stop. It was averred that the second party was forced to leave the matrimonial house on 23/3/2022 due to torture and was staying at her at her parental house. Full stop. It is also averred that the only daughter was attending the school and there was no sufficient means to maintain themselves, and accordingly the prayer was made for grant of maintenance allowance at the rate of rupees 10,000 each to the complainant as well as to the daughter. Full stop. The complaint was opposed by filing a written statement. Full stop. Para. The complainant first party had adduced evidence through two numbers of witnesses, namely herself and her brother. Full stop. In the said evidence, it has been stated, it has been deposed that on 23/3/2022, the second party had drove her out from the matrimonial house with the minor child. It is also averred, it has also been deposed that the second party was making unlawful demands of land and used to torture her for not fulfilling the demands. And such torture had aggravated day by day. It has also been stated that the second party was an advocate practicing in the Borpeta court and was earning about rupees 50,000 per month and has also landed properties. Full stop. The said in the cross-examination, however, she had revealed that she was working as a volunteer in the tele-education program and was earning rupees 2,000 per month, and this fact was not disclosed in the assets liability statement. Full stop. It has however been disclosed that it has however also been stated that the second party was appointed as a teacher in the Ratnodip Senior Secondary School, Kahibari, which was a venture school, and the daughter was admitted in the Juro Ram Pathak Girls High School. Full stop. The PW2, who is the brother of the first party, had supported the case of the first party by reiterating that there were unlawful demands from the second party, and on many occasions, the first party, bracket his sister, was driven out, in which he had intervened. Full stop. He had also stated that the second party continued to torture his sister / first party, and his sister had reported that the second party had threatened to kill her, and eventually she was driven out from the matrimonial house along with the minor child. Full stop. In the cross-examination, however, he had stated that he did not know the reason as to why on 13/4/2022, the first party had returned back to her parental house. The petitioner, as second party, had also adduced evidence through two numbers of witnesses. Full stop. And witnesses, namely himself and a colleague and a friend of his. Full stop. In his evidence, the petitioner had denied the allegation of committing any torture upon the first party and had also highlighted the aspect that he was working on working in a venture in working as a tutor, and his services was not provincialized. Full stop. He has also stated that the first party was working as a tele teacher and was getting monthly remuneration. Full stop. In the cross-examination, however, he had admitted that he was a lawyer and lawyer in the Borpeta District Bar, which he had joined in the year 2008. Full stop. He had also admitted that he had joined the Ratnadip Junior College as a teacher of education. However, his post was still unsanctioned. Full stop. Para. The DW2, who was an advocate practicing in the Borpeta bar, had disclosed in his cross-examination that the second party had been practicing in the Borpeta district court for the last 14-15 years. Full stop. He had also stated that he was earning rupees 50,000 per month as an advocate, and accordingly, the second party may also be earning of an equal amount. Full stop. The learned family court, after considering the facts and circumstances, the evidence on record, and also the affidavit of assets and liabilities as filed by the respective parties in compliance of the direction of the Honorable Supreme Court in the case of Rajneesh versus Neha, has passed the impugned judgment, which is the subject matter of challenge. Full stop. Para. We have heard Sri K. Bhuya, learned counsel for the petitioner. We have also heard Sri R. Islam, learned legal aid counsel appearing for the respondent, sole respondent. Full stop. Para. Sri Bhuya, the learned counsel for the petitioner, has submitted that there was no discernible reason which was established in the proceeding for which the petitioner, for which the first party had left the matrimonial house. Full stop. He hastens to submit that the first party had left the matrimonial house on her own volition, and therefore she is not entitled to any maintenance. Full stop. He has also submitted that the aspect that the first party was earning from her employment as educator was not disclosed in the statement of assets and liabilities, and therefore she is not entitled to any relief. He has also submitted that PW2, her own brother, in his cross-examination had stated that he was not aware of the reasons as to why his sister had come back to the parental house. Full stop. He has submitted that in absence of any reason for leaving the matrimonial house, a wife is not entitled to seek any maintenance under Section 125 of the CRPC. He has, however, submitted that so far as the order of the learned family court providing maintenance to the daughter, he is not opposed to the same and is ready and willing to pay. In support of his submissions, the Sri Bhuya, the learned counsel for the petitioner, has relied upon the judgment of Dev Narayan versus so-and-so, reported in 2003, 11 SCC 303, in which the Honorable Supreme Court has laid down that leaving the matrimonial house without any reason would be a good cause not to grant maintenance to maintenance in such case. Full stop. Full stop. Para. Per contra, Sri R. Islam learned. Per contra, Sri R. Islam learned legal aid counsel has submitted that the judgment impugned is based on relevant factors and the materials on record, and the amount granted is also reasonable and just, which does not require any interference. Full stop. He has submitted that the projection made in the present petition is absolutely incorrect, inasmuch as there are sufficient materials available in the records to grant maintenance to the first party. Full stop. He has drawn the attention of this court to the complaint wherein a specific statement has been made that there were tortures forcing the first party to leave the matrimonial house along with the daughter. He has also stated that there were no means to survive, and therefore the claim for maintenance was reasonable and just, which was duly considered by the learned family court. He has submitted that while the claim was made at the rate of rupees 10,000 per month for both the first party and the daughter, the learned family court, upon consideration of the facts and circumstances, had granted maintenance at the rate of rupees 7,000 per month each, which is absolutely reasonable. Full stop. He has drawn the attention of this court to the chief examination of PW2, wherein the aspect that the first party was constantly tortured has been specifically stated. Full stop. He accordingly submits that only because of the statement made that he did not know the exact reason why the first party had returned on 23/3/2022 will not have any relevance. Full stop. He has also submitted that in the cross-examination of the second party, it was disclosed that he had performed a second marriage in the year 2014, and therefore the allegation that there was none to look after him for which he had conducted such marriage becomes wholly inconsistent. Full stop. He has also submitted that the father of the first party has already expired, and she was staying, and she has been staying with her widowed mother without any source of living, and the amount which she is getting as a tele-educator is a meager amount of rupees 2,000, which is wholly not sufficient to survive. Full stop. He has also submitted that the daughter presently is at class 9, and there is a requirement for incurring sufficient expenditure, incurring a considerable expenditure for her education. Full stop. In support of his submission, Sri Islam, the learned legal aid council, has relied upon the judgment of Chaturbhuz versus so-and-so, reported in 2008 to SCC 316, wherein the following observations have been made. Paragraph 6, quote. Full stop. Before concluding, Sri Islam, the learned legal aid council, has also informed this court that in spite of the judgment being pronounced on 30/5/2025, till date, no maintenance whatsoever has been paid, for which even a warrant has been issued. Full stop. He has also submitted that there is no order of any stay passed by this court, and therefore the conduct of the petitioner itself is questionable. Sri Bhuya, the learned counsel for the petitioner, in his rejoinder has submitted that if the allegation of torture was actually correct, the first party ought to have lodged any complaint or police case under section 498A, which has not been done, and the same establishes that the allegations are not correct. Full stop. He has reiterated that only because of the pendency of this case, the maintenance has not been paid as per the judgment dated 30/5/2025. Para. Yeah, good question. The order, which is the subject matter of challenge, has been passed in a proceeding under section 125 of the CRPC, which reads as follows, full stop. It is right that such a proceeding is summary in nature and orders are passed on the basis of the materials on record, with the only satisfaction to be derived is that the party approaching this court makes out a case that the opposite party having sufficient means neglects or refuses to maintain. Full stop. In the instant case, the first party wife in her complaint had made specific allegation of torture and even even an attempt to kill, for which she had left her matrimonial house on 23/3/2022. There are also materials on record to show that on earlier occasions she had to leave the matrimonial house, for which MEL, inverted, had to be convened. Full stop. The aspect that the second party petitioner is a teacher in a non-provincialized post and also practices law are not disputed. Full stop. The only dispute is the amount which the petitioner as second party is earning. Full stop. The second party petitioner has also made certain allegations that the first party was herself earning by working as a tele-educator, and this fact has not been disclosed in the statement of assets and liabilities. Full stop. Para. The Honorable Supreme Court in the aforesaid case of Chaturbhus has clearly laid down that the objective of the maintenance proceeding is only to provide support to those who are unable to support themselves and have a moral claim to support. Full stop. In the instant case, the matrimonial relationship is not disputed, and it is also not disputed that there is a school-going daughter of the parties. Full stop. The Honorable Supreme Court has also taken into account the aspect of the constitutional aspect of ingrained in Article 15 (3), reinforced by Article 39 of the Constitution of India and has also observed that there is a social purpose to be achieved by the said statute. Full stop. Para. In the instant case, comma, the claim of maintenance was at the rate of 10,000 each. Full stop. The learned family court, while coming to the conclusion, had taken into consideration the relevant materials, namely the complaint, comma, the evidence adduced by the two PWs, including the brother of the first party, and also the objection read with the witnesses of the two witnesses, read with the evidence of the two witnesses of the second party. Full stop. In our considered opinion, comma, the conclusion arrived by the learned family court appears to be based on the relevant materials on record and cannot by any stretch of imagination be said to be perverse or not supported by the materials on record. Full stop. It is tried that while exercising the powers of revision, comma, this court plays the scope of interference is limited and only on certain circumstances, namely acting without jurisdiction or in excess of jurisdiction, or the impugned order being based on irrelevant or extraneous materials, such interference may be called for. Full stop. However, in the instant case, comma, the order of maintenance, that too of rupees 7,000 per month each, appears to be just and reasonable. Full stop. In that view of the matter, we are of the view that the present case does not call for any interference, and accordingly, the same is dismissed.
In this case, without observation may be made, the balance amount is supposed to be paid by the petitioner. That has to be paid within a time period.
That is
No, we are not saying anything. We will say that the law will take its own course in your case.
warrant. If
On
warrant
the
is-
aspect of non-payment of maintenance amounts during the pendency of this case, and also regarding the arrear payments, comma, the second party would be at liberty to take recourse of appropriate law.
Yes.
Highly okay.
We'll take a break of 5 minutes. Admission orders. What is it?
Admission lot,
Admission.
302 lot.
Appeal against judgment.
Admission.
Admission. Lordship.
First time.
First time. Lordship.
Okay.
On the case under 302.
Okay. What is your name?
MS Hussain.
No, you're not there on
On behalf of AM Bora, Lordship.
MH.
MS.
Heard Sri MS Hussain, Learned Counsel, appearing on instruction of Sri A.M. Bora, Learned Senior Counsel for the appellant. Full stop. Para. This is an appeal under so-and-so, against so-and-so, write everything. Huh? Admit, call for the records. Miss A. Begum, Learned APP. Mr. Hussain, you are not required to address when you prefer an appeal. Okay? It's a continuation. So there is no, it's not an application, it's an appeal. So you're not required to address the Honorable Chief Justice.
Lordship.
Take care of those. Huh? Only one, yes, A. Begum, accept notice. What else? A list after receipt of the record. List for orders after receipt of the LCR. LCR.
Lordship, we have also filed IA
I will issue notice in the IA.
and an objection because it's for imprisonment for life.
Okay, we'll issue notice, they'll file in the IA, you write, huh? This is an application filed under so-and-so, huh? Under so-and-so, praying for, take from the, praying for suspension, take it, huh? The connected appeal has been admitted today. Para. Let notice be issued, returnable on, we give a date in this. Returnable on, today is 23rd. We'll have it returnable on 30th of, not 30th, 1st of May, 1st of May is a holiday. 29th of April. Miss A. Begum, learned APP, accepts notice on behalf of the respondent state. By the next date, objections may be filed by the state.
Deeply obliged.
May I please, Your Lordship? Lordship, in this case, Lordship, paper book prepared, Lordship, but the paper books are to earlier council, Lordship, as per office note dated 10/3/2026.
What is it? I have not. Copy of paper book has been furnished to Mr. J. Mola.
Lordship. He was the earlier council, Lordship.
Okay, you are the new counsel.
Lordship,
Mr. Chaudhary will be appearing.
Lordship.
You take the copy from Mr. Mola, cannot. Take it. Okay.
Lordship.
You have been served?
We have been
Okay.
served
Okay,
for hearing your
Respond.
you are IU Chaudhary.
Ayu Chaudhary, Lord.
Hearts free IU Chaudhary Learned Counsel for the appellant who has submitted that the appeal was earlier conducted by Sri J. Mola and the paper book was furnished to him. Full stop. He undertakes to collect copy of the paper book. Full stop. Also heard Miss A. Begum Learned APP Assam Para. As paper book is prepared, list this appeal in its turn.
Lordship. Deeply obliged.
Okay, there is response number 2.
Lordship, response number 2
Who is appearing? It's a Pocso.
A. Hussain, Lordship. A. Hussain, J.U. Ahmed, Lordship.
Or they have already
Already appeared, Lordship. Their name.
Where are they?
It is not reflected in the cost.
It's there in the cause list.
There is Mr. Ames and J.
Yes.
Last occasion, they were there, Lordship.
Okay.
They are absent.
Yes.
Lordship, deeply obliged.
10-6.
Yes, Mr. Gupta.
So we have continuation of delay of
100 days.
100 days.
You have appeared for the, yes, objection.
But the delay was not reasonably explained in this case.
So your objection is not very strong. Delay has been explained, but not reasonably explained.
Yes.
So we condone the delay. Not with your consent, you have objected to the same. Okay. Heard Sri G.K. Gupta, Learned Counsel for the applicant, appellant. No, Learned Counsel for the appellant, who has filed this application for application under Section 5 of the Limitation Act 1963 for condonation of delay. Full stop. Notice was issued. Notice was issued on 31/10/2025, whereafter the sole respondent, whereafter the respondents, including the respondent number 2, has entered appearance. Full stop. Sri Gupta, the Learned Counsel has counsel by drawing the attention of this court to the averments made in paragraph 1A. He is correct, you have not explained anything.
One A.
In page number 3A, and then
1A. And B has submitted that due to reasons beyond the control of the applicant, the delay has occasioned. Full stop. He has also submitted that that there are merits in the appeal. Full stop. Para 3 देखेंगे as देखेंगे.
Yes.
Learned counsel for respond number 2. Have you filed objection?
No.
Has submitted that though written objections have not been filed, comma, the delay. Oh, yes, my brother is correct. It's a order under 125.
Yes, yes.
So why appeal?
I don't.
It has to be a revision. Appeal is barred.
At least, but
I heard the discussions earlier.
We can convert this to an appeal, convert this to a revision. In that case, I think the delay will not be there.
yes.
Only
Yes, 90 days.
90 days.
92. But
Okay. Convert code. First paragraph will remain, huh? First of notice will remain, thereafter appear, till there it will remain, huh? We have, however, noted that the appeal has been preferred against an order dated 1/2/2025 passed by the Learned Family Court, Dhubri, in a proceeding under section 125 of the CRPC. Full stop. The Family Courts Act 1984 in chapter 5 provides for appeals and revisions. Full stop. For ready reference, the ready reference section 19 is extracted herein below. Full stop. From the aforesaid, from the aforesaid provision of the statute, it clearly appears that no appeal would lie from any order passed under Chapter 9 of the Code of Criminal Procedure 1973, and it is not in dispute that the present order has been passed under Section 125 of the CRPC, which comes under Chapter 9. Full stop. However, under Section 19 within bracket 4, there is a provision for preferring a revision. Full stop. We have also noted that while the time prescribed for preferring an appeal is 30 days, correct?
yes.
30 days under section 19(3), in case of a revision, no such time has been prescribed by the statute, which would mean that the time prescribed by the Limitation Act, which is 90 days, would be applicable. Full stop. In that case, it would appear that the present application may not be construed to be barred by limitation. Full stop. Para. In view of the above, registry is directed to convert the appeal into a revision, renumber and list for consideration. This you write in both the application, huh? In both the application as well as the mat appeal. Okay, both two orders.
Lordship, date keeping fixed.
Only after the renumbering, then we cannot say. Okay. Consideration for not considered for motion. instead of consideration, but for motion.
Now 53 days, Your Honor.
53 days. You are whom? Legal aid counsel?
Yes, sir.
First time.
Yes, first time.
Conviction under what law?
Under section 376.
Private respondent is there.
Yeah, private experience will be-
Huh? Complainant is not there,
No.
right? Not required.
Not 376 not required in Pocso.
D, which is there? Required. D is required. Yes, madam, we'll issue a short notice or can we condone the delay? We condone the delay, legally. Heard. The delay politics. Heard, Miss, as Khatonier, learned legal aid counsel for the applicant who has filed this application under section 5 of the Limitation Act 1963, praying for condonation of delay of 53 days in preferring the connected appeal. Full stop. The appeal has been preferred against a judgment and order dated passed by so-and-so in so-and-so, sentencing so-and-so, everything you write. Miss Khatonier, the learned legal aid counsel has submitted that there were sufficient reasons for which the appeal could not be presented in time. In this regard, she has drawn the attention of this court to the averments made in paragraph 2 of the application. Ms. A. Begum, learned APP, has submitted that she would not have serious objection in the aspects of condonation of delay, and she would rather contest the appeal on its merits. The law governing the aspect of condonation of delay is well settled, wherein there is a requirement of taking a pragmatic and justice-oriented approach. Full stop. Considering the causes shown in paragraph 2, and also the fact that the appeal has been preferred from jail through a legal aid counsel, we are of the considered opinion that the delay of 53 days in preferring the appeal be condoned, which we accordingly do. Full stop. I stands allowed. Let the appeal be registered and listed for admission.
Lordship, matter may be passed over for the time being, Your Honor.
I for what delay condonation?
Yes, Your Lordship, there is a delay of 154 days, Your Lordship.
There is a private respondent. We have to issue notice. Is it, who is appearing, Dr. Sharma?
Yes, Your Honor.
As legal aid counsel or what?
Yes, yes.
Legal aid counsel. What is your name?
K. Bhattacharya.
Okay, we'll issue notice, madam.
Lordship.
Heard Ms. K. Bhattacharya, learned counsel appearing on instruction of Dr. G.J. Sharma,
Sharma.
learned legal aid counsel. Full stop. The instant application has been filed under section 5 of the Limitation Act 1963 for condonation of delay of 154 days in preferring so-and-so against so-and-so, right from here. Issue notice returnable on on 27th of April 2020, not 27, they say 29th of April 2026. Ms. A. Begum, learned APP, accepts notice on behalf of respondent number 1. Conviction under? Conviction under?
Under 302. 302.
So the second one is not required. Why have we made the
Because now only Pocso.
The Pocso and 376A, double A, B.
Comment.
Let steps be taken for service of notice upon the respondent number 2 in the manner prescribed. Steps within 2 days.
Vigorous. Remaining is. But German is I is always there's no mention. I will. Step 40 promise again. Assessment.
Okay.
May I please your lordship? My lord, to file this criminal appeal against the judgment and order passed by learned session judge Baksa, my lord, in which case it is convicted under section 302, my lord.
IA for?
Condonation of delay, my
I
lord.
have to issue notice.
Yes, my lord, for 20 days delay. 302.
Okay, same order, huh? In your legal aid counsel,
Yes,
madam?
my lord.
PB Bordole, huh? Miss PB Bordole. And the days is 367 days. And the judgment, all these will change, issue notice, everything. And here there is only one respondent. Madam will take A Begum, huh? Okay. So who is not there? Okay. So steps not required. Made returnable SIM 2020. What was the date? 29th. 29th.
God bless you.
Lordship, kindly see the office note dated 18/3.
Answer.
He is the original resident of that locality, Lordship, and he is living in joint family. So, Lordship, at this stage, Lordship, I may be allowed to take fresh steps along with Dusty, Lordship.
Dusty, will it be possible?
Possible, Lordship, I can.
Okay.
report, Lordship.
Third 380 Sarkar, learned counsel for the applicant, para. In this case, notice was issued on 11/2/2026, whereafter steps were taken. Full stop. Office note dated 18/3/2026 has however reflected that unserved notice on the sole respondent has come back with the remark addressee left. Full stop. 3. Sarkar Learned Council prays for a liberty to take fresh steps as well as steps by Dusty. Full stop. Let fresh steps be taken, and additionally, Dusty service is permitted, which however is required to be routed through the registry of this court. Full stop. In the notice accompanying the Dusty, the next date fixed is to be clearly reflected, and before the next date, an affidavit in proof of such Dusty service is required to be filed. Let the next date be fixed on 29th of April. Steps within, Mr. Sarkar, steps within 2 days? Steps within 2 days.
May I please, your lordship? Lordship, I am appearing in the legal aid counsel in this matter. This
Yes.
I has been filed under section 5 of the Limitation Act for condonation of below 172 days in filing the appeal.
Appeal conviction under?
Section 6 Pocso Act is involved, lordship. I have made the informative party as a respondent number 2, opposite party number 2.
Okay. Almost the same in the previous two, huh? I noticed issue, then he is U. Chaudhary, Learned Legal Aid Council against so and A Begum for 1, and for 2, you said steps to be taken for service of notice upon the respondent number 2 through the office of the PP Assam.
Lordship.
Steps within 2 working days.
Lordship.
List on 29th of April to enable filing of objection, including the aspect of service of notice upon the respondent number 2,
Obliged.
including obtaining of a report by the learned APP on the aspect of service of notice upon the respondent number 2.
Obliged, Your Lordship.
May I please, His Lordship, this IA is for condonation of delay, 584 days delay, Lordship.
Conviction, madam, under
NDPS 29, 20, under section 20 BIC and 29 of NDPS Act, Lordship.
Life, sentence to life.
Lordship. Sentence for 20 years, Lordship. Conviction for 20 years.
what has been recovered, what has been seized, what is the nature of the contraband?
It's 60.
No, 66 packets of what?
Drug.
Brown packets.
Ganja, Lordship.
20 would be cancer.
Ganja.
And it is
584 days. This way they really.
You have only said 62 numbers of brown packets. Brown packets may be having some bread and cake also. From Sheikh Brothers. Brown packets. Yes, Madam Borpachari, you have not stated. You should state it, please. Okay, we should hear this now. In the judgment, it has been mentioned, perhaps.
Lordship.
Definitely. What has been mentioned? What is the contraband?
It mentioned ganja, Lordship, scissors. Cannabis.
Okay, let us issue notice, Madam. Legal Aid Council. Madam,
Lordship.
heard Miss D. Borpujari, Learned Legal Aid Council, for the applicant who has referred, same, huh? Same, section 5, referred this application, that's right, sir. Delay of, how much is the delay?
84 days.
584 days. Against so it's a issue notice. Miss A. Begum, Learned APP, okay? And based on same date 29, by which date objections may be filed.
May I please, Your Lordship?
Yes, Madam Devi.
Lordship, here connected appeal, there is a delay of 103 days. Lordship.
Conviction under
Conviction under section 6 of the Pocso Act as well as 376 AB of IPC.
you have made the complainant a party. Okay. Miss L. Devi, huh? Legal Aid
Hello.
Council, same order. Section 5, 103 days delay, then Madam would take on behalf of 1 and 2 in steps through the office of the, in one of the Pocso cases, no, where it said through the office of the learned public prosecutor. Some. Okay. Steps within 2 working days. Give a list on 29th for same order for filing of objection as well as for obtaining a report on the status of death.
Okay, sir.
My lord, delay of 139 days in filing the connected criminal.
Criminal appeal.
Yes, my lord.
Conviction under
Section 6 of the Pocso, and my lord, no conviction under 376, but my lord, another under 450 of the IPC, my lord, for 7 years.
okay. 8 URE, huh? This is not legal aid counsel, learned counsel, no? Normal. Okay. Same section 5. Delay is of how many days? 139 days. 139 days.
Yes, my lord.
139 days against so and so. Issue notice. Then Madam A Begum for 1, 2 through the office. Okay, same order. List on 29 for filing of objection as well as obtaining a report. Okay.
Deeply obliged, your lords.
May I please, your lordship? I am appearing the legal aid counsel in the matter. There is a delay of 201 days in filing.
First
the
day, first day.
Yes, first day, lordship.
Conviction under?
302, life punishment.
Okay, 1. Okay. You, Chaudhary, learned legal aid counsel. Delay of 201.
201.
1 days. Issue notice. Only there is only one respondent, Madam will take.
Lordship.
A Begum for the sole respondent. List on 29th for filing of objection, if any. So legal aid counsel, how many days? We can condemn the delay perhaps, Madam.
Lordship.
This way, with this we are condoning, okay? This one we have already written, we have condoned the delay. Which one? What do I want to say?
Condone all the.
Item number 8. Item number 8.
Yeah, as it is statutory.
Item number 8. Huh? 7. Jesus Sharmani, 7. Same, huh? Instead of make the changes, you Chaudhary, learned legal aid counsel. Delay is 201 days. And A Begum, who does not seriously, same, everything, huh? And condone the delay, same order. Listed for allegation.
But earlier also said no, file will not file objective letter.
No, in item number 7, where, which one?
Item number 13, 14 or 103 days, 100.
No, sir, but there is one NDPS. NDPS to kori bole upare sir.
NDPS is the opposite party and delay control for
Number 12 is NDPS.
Oh,
opposite party na
okay, wherever we have passed the order, let it be. It will not look good. For here we'll condemn the delay. Huh? Heard. How many days? 200?
201 days.
20. Just as in item number 7. Okay.
Obliged, your lordship.
At least legally counsel of 3.
Yeah.
Obliged.
16.
Lord, there is a delay, my lord, of 55 days. It's a statutory appeal, my lord, matter appeal.
Against?
Against, my lord, a divorce decree, my lord.
Against?
Dismissal of a divorce petition.
Okay. The notice has already been issued.
Yes.
They have appeared.
Today, perhaps they should have appeared, my lord.
What is the office note? Notice issued to so and so, ID card, no ID card, no. Wait for some time. And if it comes, otherwise you take first steps, okay? I heard 3 has just learned counsel for the applicant. Puts the para. In this case, in this application, filed under section 5 of the Limitation Act 1963, notice was issued on 11/2/2026 and steps were taken. Puts the para. Office note dated 18/3/2026, however, denotes that neither ID card nor unserved notice has arrive back. In that view of the matter. In that view, comma, the matter is deferred to be listed after 3 weeks with fresh service report. We give a
Before
date,
Bihu, my lord, if possible.
before Bihu, give a date. Today is 23rd. Wow. Before Bihu may not be possible. On 20th.
20th,
Last week there will be nothing.
after Bihu.
Yes,
immediately.
20.
Right.
On 20th, along with fresh service report.
Highly obliged.
So if we see that it's not been served, then we might have to take, if they appear in the.
Actually, one of the others had contacted me in the morning, say that they will file their wakalatnama.
Very good, very good.
Right. Highly obliged.
And if you are certain about that, then we
Yeah.
can have an earlier date.
Yes, yes.
We
they-
can record, don't write the last line. What was it? And either so and so, neither so, neither so. Three, in that view, don't write in that view. 3, thus the learned counsel has however informed that he has received certain information. And Sri Das, the learned counsel has however submitted that he has received certain information that the sole opposite party is likely to appear shortly. Full stop. In that view of the matter, comma, matter, in that view of the matter, the appeal is, the application is adjourned to be listed on, we will give a short date there.
My lord,
On 30th, 30,
30th, man.
or first, whenever you say, 1st of April.
1st of April.
1st of April.
Highly obliged.
Okay.
Item 19, something is.
Wait, your lordship. Who's appeal against conviction, lordship?
Lordship, on this item, actually, we did not file our objection, my lord.
Okay, you'd like to file your objection? Okay, how it's, we grant some time to file. How it's MK Bora, learned counsel for the,
Sir. Apo Rosa.
for the applicant.
Yes.
Para, Ms. B, we are learned additional PP Assam, however, renews her prayer for grant of more time to file objection. Full stop. How much time? 2 weeks? Matter. The matter is accordingly adjourned to be listed on, we give a date
After the.
after Bihu.
Yes.
To be listed on 22nd of April 2026, by which time objection is required to be filed. Objection may be filed.
Obliged.
Evening. For your.
Please, your lordship. I think this will take time, lordship.
We'll take it at 2 o'clock. What's
Yes.
the matter?
Matter is about Pocso matter, lordship. The
Paper book prepared.
paper book is ready and the matter has already been heard.
Rings.
Yes.
Yes,
Of
yes.
the victim, as well as victim,
But-
not the accused person.
Birth certificate has already been decided not proved, lordship, in this matter, as per order.
Rings.
2 years margin of error, yes.
Plus minus. No, range is the same. That is plus minus regular, no?
Lordship, that's not part.
For this page.
Just part, huh?
No.
No.
That's why otherwise we don't count for this. But I was in that.
Yeah.
Okay, at 2 o'clock.
Alright.
But this bench will rise at around 3:15, maybe at 3 o'clock. We have today, tomorrow, day after.
Take much time.
Okay, we'll finish it.
In this matter, Lordship, the birth certificate which has already been decided did not prove. Now the question is whether the margin of error 2 years has been benefit has been given to the accused. And in this regard, we have made some compilation of the judgment, Lordship.
You have to narrate the facts.
Correct.
Presume that we know anything.
Lordship,
What are the facts? What had happened? How many witnesses? Everything.
Lordship, in the incident was occurred on 24/7/2023. The accused took the accused.
What is your name?
My name is B. Kumar, Lordship.
D. Kumar.
B. Kumar.
B.
B. Kumar. And the accused name is Lordship Ritu Bodole. FIR.
Just a minute. Procedural, Jahar.
FIR is at page number 3, Lordship. Azhar is page number 3, Lordship.
Okay.
Azhar lodged on 25/7/2023. May I read the Azhar, Lordship?
Just a second. Wait, border. It was initially registered as under 365.
Yes, Lordship. 365. And subsequently, Pocso section 6 and 376 has been added. And charge sheet was filed on 26/7/2023.
Just a minute.
Six PWs and two DWs, right? Six PWs and two DWs.
Yes, there are total 9 listed witnesses, but prosecution choose to only examine 6 number of witnesses, including MO and IO.
Informant is PW2.
Yes. Informant is PW2.
When was this FIR Jahar registered?
FIR registered on 25/7/2023. At page number 1, Lordship.
Information received on 26. No, information was received on 26. 26 at 19:30 hours. Azhar is dated.
26. Sorry.
Azhar is dated 25.
I'm sorry.
Received on 26.
Sorry, Lord. $26.
19:30 hours. Occurrence 24/7. Yes. Let us see. Let us see. Let us see the Ajahar.
Ajahar, Lordship, page number 3, Lordship.
I have. Please read.
The humble submission to informant is that on 24/7/2023, the above mentioned accused took away my minor daughter, so and so, as about so and so, so and so, so and so, saying that she had a volleyball game selection in Gauhati. My daughter has not returned home till then. We mentioned that the said accused is a married person. His wife came to our house and informed us that her husband made my minor daughter eloped with him. I therefore